Our last conversation for the day is on examining global privacy legislations and the lessons for India, and it is between Julie Brill, Chief Privacy Officer, Microsoft, and Rahul Mathan. But we will begin this conversation in 5 minutes just to give Rahul Mathan a little bit of a break since he was the moderator for the previous panel as well. So see you all in 5 minutes. Welcome back for the conversation between Julie Brill, Chief Privacy Officer, Microsoft, and Rahul Mathan, Partner Trilegal. In this conversation, they will examine the global privacy legislations and their effect and lessons for India. Rahul.
Two, go.
Welcome back. If you've just come back from the previous session, this is the last session of the day, and what a pleasure it is to be sitting here and talking with Julie Brill, Chief Privacy Officer of Microsoft. Julie is currently the Chief Privacy Officer of Microsoft, but she served as the chairman of the US Federal Trade Commission for 6 years. While she was at the FTC, she was named the Commission's most important voice on internet privacy and data security. Julie, thank you so much for doing this and for agreeing to sit and have this conversation with us. I'm really looking forward to it.
I'm looking forward to it too, Rahul. Thanks to you, and thanks especially to the government of India and Carnegie India for creating this event and for having this very important conversation.
So Julie, we're at this point in time everywhere in the world where it seems like there is this sudden proliferation of data protection privacy regulations. I mean, the GDPR, of course, came into force in 2018, and you've had a lot of experience actually piloting Microsoft through GDPR. But equally, in the US, there is this federal legislation that people are talking about. There is California legislation. There are many countries around the world, including India, that are literally on the verge of passing new significant data protection regulations. What is it about this point in time that is causing the countries of the world to give privacy and privacy regulation this level of importance?
The global interest in privacy, in my experience, has never been higher. In my nearly 3 decades of working around privacy, data security, and related issues, I've never seen as much interest in this issue as we are currently seeing. Privacy is having a moment in history. And I think the reason is because people want to own their data. They do own their data, but they also want to be able to control it. And right now, people are feeling out of control in today's environment. With the number of services and tools that individuals use, they have to use in order to navigate the modern world, it has become very complicated. Browsers, search engines, social engagement, financial services, connected devices with voice commands, medical services, all require individuals, if it's left just to them, to control a very complicated environment. So I think governments around the world, policymakers around the world, and constituents around the world say, we want companies to act responsibly and to protect data. It's really about building trust. When you think about it, to your point about the number of countries that are adopting laws, back in 1998, there were about 20 or 30. Most of them were in Europe, frankly. Now there are over 130 jurisdictions that are either adopting a privacy law, have adopted one, as you said, California, Brazil, or are considering very robust legislation as is happening in India.
And if I may ask you, because you're right, I think it's really because of our reliance on technology that, particularly after the pandemic, we've never been more reliant on technology than this last year. And there is a dichotomy there because, technology needs data in order to provide us better services and work its magic, as it were. But at the same time, when it has access to that data, there is a risk to privacy. So, how do companies, governments, even individuals who use this data, how should they be thinking of arriving at that balance?
Yeah, I think you make an excellent point, Rahul. I think that the pandemic has really demonstrated one of the chief challenges that governments and regulators and people face when it comes to protecting privacy. Because as we saw in the pandemic, we need to be able to use data in innovative ways and in robust ways to help control the disease and to bring society back together. And yet it's because so much of that data is deeply personal. It's about people's health and about where they're going and who they're interacting with, that people really need to understand that their data is going to be used for the particular purposes, for health and for bringing society back together, and not for other purposes. They need to know that companies are going to use this data And governments are going to use this data in responsible ways, but also protecting privacy. I think that's the balance that needs to be struck. It is to make sure that data can be used in robust ways and in innovative ways, as in solving the crisis, but in many other ways, whether it's education, skilling, the environment, global, climate change. All of these are ways in which we need to start using data in innovative and robust ways, and we need to protect privacy. So that balance is going to be critical going forward.
And we are, of course, in a global economy, and I've just come off of a panel where we discussed sort of the geopolitics of technology, and of course that's sort of the theme for all of GTS. But the words that were thrown around, and quite frankly, they've been thrown around through all of this day, is words like balkanization of the internet, and we feel that there is this challenge to data moving across borders, but of course, it's absolutely essential for data in many cases to move quickly across borders. We just need to think of the pandemic, the fact that we already have a vaccine that's been administered in, at least I understand, the US. The first vaccine was administered today. The UK has administered the vaccine. Never before has a vaccine been created as quickly, and it's all because our globally connected world has allowed data to move so quickly. But at the same time, we have this challenge of cross-border data flows. We earlier this year, we had the Schrems decision, the second Schrems decision. So if you could reflect a bit on that, the fact that we need data to flow so badly, but at the same time, there are all these restrictions that are being imposed on them.
Just to take a second, the Schrems 2 ruling that you just referred to was a very consequential ruling. It doesn't actually change right now the ability of businesses to transfer data from the EU to the United States, or from the EU to many other countries, India, Brazil, elsewhere around the world. As long as those companies that need to transfer data are doing so with standard contractual clauses and with additional measures to protect that data. The ruling did invalidate one transfer mechanism, but I'm deeply hopeful that the US and the EU will be able to reach an agreement with respect to rebuilding a transfer mechanism for data to flow between Europe and the United States in particular. But look, taking a step back, it is true that data flow, and really the flow of ideas, which is what data flow is about, it is very important for the world. It's important for business, but it's also important for consumers and for workers and for governments, frankly. And so we need to be able to build appropriate paths for data to flow between India and the United States and India, between Europe and the United States and vice versa, and between Europe and India. We need to be thinking about what are the kinds of protections that need to be put in place so that data can flow. One of the things that was at the center of the concerns around the Schrems decision was how governments, in particular foreign governments outside of Europe, were accessing the data for national security and law enforcement purposes. There is a need to protect citizens. National security is important. Law enforcement is important. So I believe one of the paths forward to really addressing this issue around one of the concerns why data is localized, to try to protect it from foreign governments. I think the real answer is to be thinking about how we can protect individuals and make sure that their privacy is protected in the context of government access to data. It's not just about foreign government access, it's also about domestic government access, of course. And so what I think we need is for the globe, really, or you know, like thinking countries, the democracies of the world, to really be thinking about what are the multilateral engagements that we should be engaging in to create appropriate safeguards for government access. I think that will address one of the chief concerns, if we can get to that place, which I am deeply confident we can. If we can get to a place where we believe that government access is appropriately balanced, because there is a need for national security, there is a need for law enforcement, and that means that data needs to be provided to appropriate agencies, but in appropriate circumstances and with appropriate safeguards. If we can get to that place, I believe that one of the chief concerns around data locality and why data is under that pressure by policymakers to be localized or to be copied in location, I think that will address one of the chief concerns.
I'm glad you raised that fine distinction between the location of the data and access to the data, because quite frankly, no one really cares, even law enforcement, where the data is, as long as they can access it. But this is not easy to do. And I know you said that is a solution, but may I ask you push you a bit to say, what would be the approaches to try and find a solution to this access problem? How should we set it up such that all the countries of the world and all the companies in all the various countries of the world can agree on this access question? Because if we solve this, I think we can solve so much in what's the challenges we're facing both in the EU as well as in India with our localization laws.
The Schrems Court presented a pathway forward in terms of access issues. One of the things, or the things that the Schrems Court focused on were, do companies, as they're transmitting data and sending data outside of Europe to other countries, do the companies have appropriate additional safeguards in place? Some of those safeguards would be things like encryption, appropriate encryption. Some of the other safeguards would be operational controls, making sure that only those entities that have authority to access the data do so. We at Microsoft have actually taken additional steps. We have recently announced a program that we call Defending Your Data, and we have made commitments that in all appropriate circumstances, when governments outside of Europe seek to obtain information about European data, we will, again, when there's a lawful basis for doing so, challenge the access to that data if we believe it is not appropriate under the law. So companies have a role they can play by ensuring that their customers' data, enterprise data in this case, that's where our program is focused, is protected. So the Schrems Court also pointed to one other issue that I think is equally important to the sort of operational and technical and policy controls that can be put in place by companies. The other issue is redress. How do we ensure that individuals know what is happening when their data is accessed by law enforcement or national security? The European member states actually do this very differently. There's not a uniform way that they do this because those are the kinds of rules that get adopted and enacted at the member state level, not at the European level. Similarly, the United States has one of the most robust regimes around ensuring that law enforcement and national security systems are appropriately accessing data through what's known as the FISA court. But there are ways in which I think even in the United States, we can provide a bit more transparency and also provide individuals in Europe or other jurisdictions that have these same concerns with the ability to understand more about what is happening to their data.
Julie, we've got audience questions that are already starting to come in, so I do want to give the audience an opportunity to address some of these questions to you. And here's one that I think, just given your experience both at Microsoft as well as in the FTC, might be a good one to pick up. The question is essentially around the heavy costs associated with GDPR compliance. And the question, I think, is more specifically in the context of small businesses. And I think big technology companies, as much as they have a heavier burden, also have a much better capacity to deal with this. And I think the question focuses more on, and perhaps this is in your role as the FTC commissioner, as a regulator, how would you have thought of it, in the context of actually how do small businesses deal with that compliance burden?
So it's a great question. So thank you to the audience member who sent that in. At Microsoft, we actually think about this a lot because, when the way Microsoft succeeds is by having our customers succeed. And we have customers that really span the gamut from very large companies to small, innovative startups and everything in between. So I did think about this when I was a commissioner, but I still think about it. My chief focus for small businesses is to think not so much about the size of the business, but about the behavior of the company. So it's important as you're thinking about laws, developing laws and setting up new data protection agencies, as the India system will obviously be built out and there will be a new law. Think about what companies are doing with data. So Cambridge Analytica, just as one example, was a very small company, but it was engaged in some very risky practices. So one of the other things that I found, in addition to thinking about practices, as well as size of a company, but practices too, is also to thinking about agility of companies. So there are some small companies that are building themselves right now that can build towards GDPR compliance. Then there are some very large older companies, medium-sized, large companies that have legacy systems that have a lot of retrofitting to do in order to bring themselves into compliance. In some ways, I think the real key to being able to comply with GDPR easily, and I'm putting that in air quotes, right? I mean, it's a complex law and it's one that you have to think deeply about, but it's those companies that are more agile as opposed to those that have legacy systems. Still, there is a point that the question makes that, the more resources you have, that also helps. And I do think that even the GDPR and the regulators have recognized that through scaling the kinds of obligations that they are putting in place. So sensitive data, to the extent that a company has sensitive data, that's going to be regulated in a stricter way. To the extent that you're engaged in large scale processing, right? Then that's another issue that the regulation looks at. So and then of course fining, and having fines sort of scaled to the size of the company, among other things. These are all ways in which I think you can address the size of the company, but I think only focusing on that will really miss some important elements of what data protection really should be about.
No, that's fascinating, and clearly that is just experience as a regulator shining through. We're close to the end of our time, but I don't want to leave without asking you for just a few words of advice to India as it is about to embark on this new privacy regime. And we are, as you said, going to have our data protection authority soon. But India has, unlike Europe, Europe had 30 years to get ready, 20 years to get ready for GDPR. India is just jumping into this headfirst for the first time. What should the priorities of a new data protection authority be for a country at this stage of its development in the privacy field?
Yes, it is so It is so fascinating what is happening in India. And as you pointed out earlier, the same is true for the state of California, which is going to be creating basically a data protection authority for the first time in the United States anywhere. The U.S. Federal Trade Commission is the functional national data protection authority in the United States, but there is no state level data protection authority, and there is no one agency that is an agency whose sole mission is data protection. So I think for California, for India, and for Brazil, which is also setting up a new data protection authority, one of the most important things before you ever get to the regulator is ensuring that the law sets out the priorities for how data can be collected, used, and shared. What is the accountability that companies have? That is the responsibility that companies have. Is there transparency in terms of the practices of companies? And then enforcement. There needs to be strong enforcement. So if you hit those pillars, actually, there's also one other very important one: consumer control. That is, how will users control their data? What are companies' accountabilities? Is there transparency, and is there strong enforcement? The law should be clear on all four of those pillars. Then it's important for the regulator to start developing guidance, especially in an area like California, where it's a brand new law. India, it will be a brand new law. Same with Brazil. What do these provisions mean? What do companies actually have to do? And, there have been agencies in the past, including my former agency, the U.S. Federal Trade Commission, that have been a bit shy about being specific about guidance. I think in this day and age, and frankly, I think the U.S. FTC is now embracing this too, the guidance needs to be clear. It needs to be robust guidance so that people really understand what they have to do. Another critical thing is ensuring that the regulator has enough resources. That's back at the parliament level. The agency needs to have enforcers, needs to have educators to start building out this guidance to explain what the law means, and the agency needs to have technologists to understand this very complicated ecosystem. And then finally, the regulator is going to have to get that balance right, the balance that we talked about before, the balance between innovation, robust use of data to solve society's problems, and protecting that data to ensure that people have trust in how data can be used. It's not an easy balance to strike, but that's what the regulator needs to focus on every single day.
Julie, thank you so much. We're out of time, but I just feel that next year for the Global Technology Summit, Carnegie had better bring you down to India so that by that time, hopefully the Data Protection Authority would be in place and you could share these words of wisdom directly with the authority. Thank you so much for spending the time. It's been fascinating. There's so much more to talk about, but I think we'll have to leave it for another day. Julie Brill, it's been a pleasure.
Thank you so much. I so enjoyed the conversation. Thank you.
And this brings us to the end of the first day of GTS 2020. A big thank you to all the panelists for the scintillating discussions on the geopolitics of technology today. A special thank you to the Honorable Minister, Dr. Jay Shankar, for sparing the time to deliver the inaugural remarks and for the special conversation. Tomorrow, we will begin our public sessions at 5:40 p.m. IST, and discussions will examine the role of data in linking today's world. Do join us. Before you leave, I'd like to request you to fill the feedback form available on the platform if you haven't done so already. Thank you for watching. Enjoy the rest of your day or evening, as the case may be. Thank you.